and the public at large saw that the foundation on which prosecutors had always built their cases was rickety at best. DNA could offer irrefutable evidence that someone else, almost certainly not the suspect in custody, had raped or killed the victim. DNA proved that evidence such as eyewitness testimony, ballistics, hair comparisons, fingerprinting, even confessions from the suspect could be flat out wrong. But if DNA is a deus ex machina for innocent prisoners, it is a selective God, visiting only 10 to 20% of crime scenes. Like the vast majority of prisoners who claim to be innocent, DNA could not help Ben Spencer. Without unassailable forensic evidence, Spencer's several appeals failed. Even as some states have tried to avoid mistakes with new procedures and better science, they cannot fix two problems at the root of the U.S. criminal justice system: the human mind and the human body. Can a witness accurately record and replay a crime that takes place in a split second on a dark, moonless night? What if the witness is poor or has an axe to grind? Can science erase the motive to lie? Jailhouse informants play a leading role in murder convictions, an astonishing fact unique to the United States. What is to stop these criminals from trading bogus confessions from the suspect for a shorter sentence for themselves? Police, rushing to find the culprit while the trail still has scent, have been known to discard or ignore evidence that points away from their suspect. Prosecutors have rationalized burying a piece of evidence because it muddies the clear story they are trying to tell in the service of justice. If convicting the innocent is the natural result of human error, undoing the mistake is thwarted by the legal system, specifically by the concept of finality. Appellate judges rarely overturn jury verdicts. After all, they did not sit in court listening to evidence and assessing witnesses. So who are they to second-guess the jury? And while Americans now recognize that the government routinely convicts innocent people, Congress and the U.S. Supreme Court have narrowed the path to freedom for the wrongly convicted by systematically blocking the federal court's ability to review a jury verdict, even in the face of obvious innocence. On a personal level, Ben Spencer was 22 years old when he was arrested, newly married to Deborah and expecting a child. At first confident that the police would sort things out, he watched in disbelief as he was indicted, convicted, sentenced to life in prison, and denied parole year after year. The toll on Spencer, on his wife and son, on his family and friends, on their faith in God and in the law can never be calculated. These private narratives are almost always hidden, but Ben and Deborah Spencer have allowed us the rare privilege of surveying the wreckage the system has wrought. For several months during 2020 and 2021, I lived in Dallas trying to uncover new evidence and solve the murder of Jeffrey Young. My efforts felt futile at times. Once the Texas legal system found Ben Spencer guilty, it was as if that judgment sealed him in amber, and he needed an extraordinary instrument, such as DNA, to free him. Without this scientific cudgel, Spencer's lawyers and investigators had to make do with something akin to an ice pick, trying to chip away at his conviction, filing writs and parole applications, petitioning one district attorney after another, hoping that these efforts would eventually crack apart his case and release him as an innocent man. The 37 years since Spencer was incarcerated have seen a reckoning. Defense attorneys across the country began publicizing wrongful convictions. The public noticed, as did judges, legislators, and a new breed of prosecutor. Rather than simply denying the mistakes, most states began to recognize that prosecutions can go off the rails, and some have tried to eliminate the most egregious flaws. In a happy surprise on this issue, the most progressive state in the country is Texas. In part because the cost of error is so high, the state executes more people than any other. Texas has set up a number of guardrails and is by far the state that most generously recompenses its exonerees. Thus, Texas is the perfect starting point to begin and end the story of Ben Spencer, the logical place to examine